This is Scott Drake. You're watching the Legal Broadcast Network. My guest is Chris Davis. He's a Seattle personal injury attorney, and he writes in a recent blog about a client he's representing whose Facebook page cost him $20,000. Welcome, Chris. Thanks for talking to us.
Thanks, Scott. Glad to be here.
Well, let's explain what happened here and what the problem was.
Well, it was, as a personal injury attorney, you see a lot of car accident cases, and so it was your typical car accident rear-end case. And the case had been in litigation for maybe about 18 months. And, I worked the case up as I do any other case by hiring experts, collecting records, prepping the client for depositions and so forth. And about 6 to 8 months ago, we as a firm, sent out a notice to all of our clients about the potential problems of these social networking sites and having photos and videos that could come back to haunt clients in their cases. Well, unfortunately, in this case that we're talking about, that client never got that notice or ignored that notice, but about 30 days before trial, I received from defense counsel a CD-ROM containing several photos and video showing my client snowboarding and going off jumps on his snowboard. So the problem was that he was in a car accident a few years earlier, and he was claiming neck and back injuries with some degree of permanency. And I was, telling the adjuster throughout the entire case, as well as the defense counsel, that my client was seriously injured. He had thousands of dollars in medical bills. He was still having problems, and that the doctors were telling him he would probably need future treatment. So when I received this information from defense counsel, you could say that I was surprised, to say the least.
Well, it's fairly common for, in this case too, for this thing to take 3 years and to have a substantial amount of recovery on your client's part. Obviously, as you wrote in your blog, it's a problem of perception with a jury, right?
Yeah, absolutely. And that's, what my client did not really understand, because, in a trial like this, you're only talking about 3 or 4 days tops. And it's about really, in that short time frame, trying to persuade the jury, show the jury that what the person went through was, fairly, I want to say that the client went through a problematic time, was injured, received treatment, affected his daily activities, affected his hobbies, and so forth. And there is usually some degree of recovery, but when you have a piece of evidence, a video showing the client doing a fairly rigorous activity, and the jury sees that in the trial, that's usually going to be the last impression that they're left with before they go back in the room and deliberate on the case. So it would be very difficult for me as an attorney to argue that my client was severely injured and had a tough time, when in the back of their minds, the jurors' minds, they're seeing this video of my client, and he looks great, and he's doing these, remarkable maneuvers and going off jumps. The other thing it does is it raises the possibility or speculation on the jury's part that, maybe he injured his back while snowboarding. Or maybe he did something before this auto accident that contributed to it.
Right.
It really encourages a jury to speculate, and it really feeds in, I believe, to the pre-existing bias that a lot of the jurors already have when it comes to injury cases. And
when you speak of pre-existing bias, you're talking about a bias that a jury most likely thinks that the injuries are not as severe as they're portrayed?
That, and there's, a common misconception that, lots of people are making large amounts of money for minor injuries. They're thinking in the back of their minds that, if we allow a large verdict, our insurance rates are going to go up. The plaintiff is sitting in court and looks fine from the outside.
Right.
The jurors hear all these stories reported in the media about all these frivolous lawsuits and so forth. So, my job as a plaintiff's lawyer is already stacked against me and my client before we even step into the courtroom. So if I have to deal with some pretty severe or damaging evidence on the other side, like this video, it makes it even tougher, almost impossible then to get a fair result in a trial like this.
It also speaks to the lengths that insurance companies now will go now to research a particular case. It seems like now that's probably a Facebook, Twitter inspection is probably routine now.
I have to believe that the carriers there now are, as a matter of routine, looking for any information on the social media sites like Facebook, MySpace, and Twitter. And so, on one hand, I was surprised to see this come in, but on the other hand, I know in my experience of, doing this for over 15 years, the lengths that the carriers will go to dig up anything on the plaintiff who's claiming injuries like this. So, yeah, you're right in that respect.
Was he able to recover any damages or medical costs?
Yeah, I was able, I was able to get enough to cover the medical. Mm-hmm. During the negotiations, I told the adjuster that I had felt the case was worth at least $20,000 more, and her response was, "Well, you might be right. Had we settled this before we came into this information." Right. Which is why I titled my blog post, my client lost at least 20 grand. But I was able to get something, but probably half of what I think the case was probably valued at.
So now, is this part of a blanket warning that you give now to most of your clients?
Yeah, I mean, I probably am guilty of not taking this more seriously. As I said earlier, we did notify clients about 6 months or so ago, but now I think we're going to have, as part of a new client sign-up, we're going to have a separate sheet of paper mm-hmm. that basically says warning. What you post on these social media sites can really hurt your case. I may even go to the length of having the client initial it at the initial meeting, right? Mm-hmm. So that I'm sure that the client was given that information, and we'll probably periodically send out reminders to all of our clients, either through email or letters, about the potential harms that photos and videos and the like that can what they can do to their case. So definitely.
But it's okay if they post pictures right after the accident.
Oh yeah, I mean that's fine, and it's okay if they post pictures of them being, engaging in activities, rigorous activities that they enjoyed before the accident.
Right.
But they should probably make that clear. I mean, if I had if I had my way, I'd say, don't post anything, because anything can be taken out of context, right? But even if I have a photograph of something before the accident, if an insurance adjuster finds that, it's just one other piece of ammo, one other hurdle that I might have to overcome, and so it may take more work and effort. But, certainly they can post photos of things, but just be aware. I mean, the question I would tell them that they should be asking themselves, will this hurt my case? Will this make it appear that I'm either exaggerating or not telling the truth in my case about my injuries and how my injuries have affected me?
Have you run into any other cases with a similar problem?
No.
Okay.
No, I mean, this is the first one. I've had a couple other cases where I've had the client has told me that they thought that somebody was looking for information on them because one of their friends or a few of their friends have been contacted. But this is the first case where I actually had damaging information that was pulled off a Facebook or MySpace account and submitted as part of an evidence submission in the case.
Chris Davis is a Seattle personal injury attorney, and he's got a nice blog post about a client of his he's representing whose Facebook page cost him about $20,000 in damage awards. Chris, appreciate your time today.
I appreciate it, Scott.
And this is Scott Drake. You're watching the Legal Broadcast Network.